introduce Daliah.
Thank you, Nima. Okay. So, hi everybody. I decided instead of giving you like a really dense PowerPoint presentation behind me, I'll speak to you about the different issues affecting photographers. I did give a presentation to a different photography group, what is it? I don't know, 4 years ago or so. And that presentation, you can get by going to the website and look at it. And if you want any specific information or answers, just call me or email me and I'll send you an updated version. But generally speaking, I want to cover today what, first and foremost, a copyright is. Are you all familiar with the concept of copyright law and how that's different from trademark law and patent law? Maybe I should start there because I feel like a lot of photographers or creatives will call me and say, can I trademark my copyright? Can I patent my copyright? And they use the various IP terminology interchangeably. Who knows what a trademark is versus a copyright? Not really sure. Okay, so we'll do that. I'll give you an overview of what intellectual property really means. Then I'll go into what copyright law provides to the photographer, which is the intellectual property law or subsection that is the most relevant to you. And then I'm going to give some case examples that cover what public domain is and fair use is and what a work for hire is. These are all terminology that photographers hear, but again, aren't always clear what they mean. A little bit of background on me. Yes, I started my firm about 9 years ago as not someone too old or, you know, one would perceive a lawyer to be. So what I did was focus on all things digital and online to attract others who were in that space. So as a result, the firm has kind of created this niche in the digital and online space, which makes sense because most of you are probably taking digital photography, you're distributing your content online, and so there are a whole slew of issues that cover that. So what I hope to also discuss during the presentation is the concept of ownership as it relates to uploading to the internet. Does Facebook own your pictures? What happens if you share someone's pictures? What is it a link okay? Can I pin something? And those are the kind of questions we're getting a lot as well in the office. So let's start with, and I have no presentation, so I can just talk. Okay, so let's start with what intellectual property is. Intellectual property typically discusses, under its umbrella, patent law, trademark law, copyright law. And trade secrets are kind of a brother and sister of those three, but for the first and foremost, those patents, trademarks, and copyrights are what you have to be worried about. Patents cover an invention or an idea. So if you have an idea for how a photograph should be arranged, you know, I have a process by which I take photographs of shoes using this shutter speed, then maybe you can get a patent in the process so long as you disclose in the patent via certain claims exactly what the methodology is behind the idea that you have. Most of you will never get a patent or be able to because of what's called prior art. Yep?
Google supposedly or patented or Amazon patented a technique that's been used since the 1800s. Okay. How does that affect?
Well, if you look closely at most patent applications, what you'll see is patents are based on claims. Disclaimer, I'm not a patent prosecutor. Patent lawyers have to have a science background. It's not what I do. But I know enough to tell you that a patent application has to take very specific recipe for how to do something and list it. So although something may be around for a long time, I bet you that if you look closely at what was actually patented, it was some improvement or subsection of what has been around for a long time. Most of the time what you're seeing in the space of photography patents is some sort of, you know, face recognition or software that analyzes the photographs that we disseminate. None of you, I think, are in that business. You're in the business of making the photographs, not tagging, sharing, collecting data off of them. So let's throw patents away for now. Now, trademarks. All of you do need to worry about trademarks to the extent that you're creating businesses and goodwill around your name, the brand that you use to sell your photography services. So trademarks really just cover your brand name. What you use, whether it's a logo, a phrase, just a simple word to cover your business. So Chicago Photographic Society is the name, the brand that this organization operates under. Many of you probably just use your name, your first and last name, right? Does anyone have a unique name? Like I had a client that's called Stop Time Photography. Yeah, what's yours?
A-Party.
A-Party? Okay, anybody else?
And that goes by really boring.
That's the name of the company?
Well, that's his Flickr name.
Really boring. Okay, but that's fair. Handles and online, that domain names can serve as trademarks, yeah? iPod. iMot. Okay. So, assuming you're not just using your name, and even if you are, I'll cover that as well, you probably want someone else to not use that name to sell photography services or anything that's remotely in your realm. So what you want to do is get a trademark. A trademark provides you federal protection against anyone from using a name that's confusingly similar to yours. So in the stop time photography example, my client had her name and then she had stop time underneath. Someone else in a different state was using stop time as the main portion of the trademark, and she was really upset. So she called me and said, well, now when you Google stop time, there's two stop times. I don't know, people are confused which photography company is providing the service. What can I do? So what can you do? If you don't have to get a federal trademark registration. Essentially, all of you, by virtue of selling whatever it is you're selling, your services, are in business, and you can all right now just put a TM next to your name and have a trademark protection. However, absent that federal trademark registration, your rights are only as good as the area in which you are selling. So if you're a Chicago-based photographer and all your clients are in the local, the 5-mile radius around you, and you can't really demonstrate a reach beyond that, then tough luck. Someone else in a different state or out in, Schaumburg can theoretically use your name and also operate under that name. So if you at all want a national presence, then that federal trademark registration says, I've staked my claim in this word or phrase for photography services, no one else can have it. Names are a little bit more difficult to protect. The trademark office finds them to be essentially descriptive. And if you're, John Smith and you have a business, you can't really prevent someone else from calling their business John Smith. Caveat. If you've been around for usually more than about 5 years, and your name has acquired distinctiveness, meaning we all know who Giorgio Armani is. We all know what McDonald's is. Or, there's certain first and last names that we associate with designers, photographers, and whatnot. In that case, then even your name can acquire trademark protection. And you can prevent someone with a similar name from using their name to sell services that are confusingly similar to yours. Yeah?
How do we prevent somebody from acquiring a similar website?
A trademark would also allow you to do that. So what you would want to do is once you get the trademark registration, if you see that someone's registered a domain name that includes your trademark, you can say, take it down, it's confusing, you're using my trademark. Okay.
When you say confusing, or I noticed you used the phrase remotely close, is that saying the trademark gives you some flexibility, some range, of saying
yes.
You can't even...
Yes, so trademark law is actually not meant to protect the business owner. Trademark law is all about the consumer. We want to make sure that the consumer knows the source of the services that they are buying. So when you bring a suit as a business owner, what you're really saying is that by the defendant using a phrase similar to mine to sell photography services, the end consumer is confused as to who the company is that's selling the services. Now, let's say you register stop time photography, but someone else has stop today, or I don't know, something that sounds like stop time but isn't, or stop lime, all right? Someone else is stop lime photography. You could still bring a cause of action and say, all right, I know it's not the exact word, but someone might think that stop lime is a subsidiary or some other version of stop time. You need to stop. So that's really trademarks in a nutshell. You can also actually have trademarks in packaging. So maybe you've developed a really cool way of presenting your photography or your albums, and people know, oh, that's, Bob's package, and it always comes that way. Then you can get a trademark in the trade dress and the look and feel of what it is that you're presenting to consumers. And a famous example of trade dress is if I say, here's a small box in turquoise, that's all I said, a turquoise box. And you guys all knew exactly what I was talking about. I mean, smells can be trademarks. If I walk by someone and I sniff their perfume, and that's a signature smell, Chanel No. 5, you can trademark a scent. It really doesn't matter what it is, so long as that phrase, that trade dress, people know belongs to a certain company. So as business owners, whether you're selling widgets or you're selling jewelry, you're selling food, or you're selling photography services, if you care about the goodwill and the name that you're developing in your brand, you want to get a federal trademark registration. What does it cost? $325 is the government fee, and the legal fees can range depending on what kind of law firm you go to. Yeah.
What happens if you apply for that and it turns out that somebody already else has something similar to that?
So prior to filing a trademark, you always want to conduct a trademark search. For you, it's as simple as a Google search. If they're not really present online, then you're probably safe. Now, let's say your stop time for your photography service, but then there's a restaurant called Stop Time. Would that prevent you from getting stop time photography? Why not? Right, so the end consumer would never affiliate the restaurant with the photography services. Beyond that, what we do in my office is we first search the trademark docket. We want to look and see what has already been applied for or registered in connection with the name that you're looking for, and we'll say, you have a good chance of getting this through, you don't have a good chance of getting this through. It may depend on the examiner. The examiner is a lawyer that works for the United States government that gets your application and reviews it for conflicts with other marks, for the description, and so on and so forth. And I can talk about trademarks for a long time, but I think what we really need to focus on for this presentation is the copyrights, since that's, yeah.
The trademark, the fee you pay, is it just once? Or
You pay one time, $325, and that doesn't mean you get a trademark. That's just the application fee. So a lot of people, I get a lot of business from LegalZoom type people who've gone online and just filled out the form only to get an office action rejection, or there's something really wrong with it on its face, and they have to just do it again. If you're not really worried about it, it's a deceptively simple form to fill out, but there are a lot of nuances over what class to pick, how you craft the description, what the date of first uses, and again, I don't think we want to talk about trademarks too long. Yeah.
Just one.
Yeah. All right. Go ahead. We'll do trademarks.
Is there any difference in the standards of trademark being a tagline as opposed to a...
There's no differences. SM and TM, they're all the same thing. So what you can never trademark are generic terms, which, if I'm trademarking jacket for jacket or watch for watch, you'll never get a trademark for that. Similarly, the trademark office doesn't want to give you descriptive trademark rights either. So Chicago Photographic Society, not a great or strong trademark because it's exactly what it is. You guys are Chicago-based and your society for people who take photographs. So until you've been around for maybe 5+ years, if I want to start a Chicago photo society, best is probably still just puffery, right? Also arguably descriptive, and we get that a lot. Chicago painter, Chicago this, and I'll say, sorry, there's really not much I can do until people really know who you are. An example is I represent Sausage Fest. You guys, right? It's kind of funny. We had a real field day writing the office action response to that one. And saying, Sausage Fest can mean something else. And ultimately they said, well, you're a festival that focuses on selling sausage. And we're like, well, so now we're trying to say the festival's been around for at least 3 years, 4 years. We've spent a lot of money advertising it. Now when people hear Sausage Fest, they know it's a specific festival, not a festival for sausage. A silly example, but one that we literally are handling right now. Okay. Okay. So let's get to copyrights, because I think all of you need to know what copyrights are, and you need to know how to just fill out those registrations. Unlike a trademark, which requires some knowledge and some search to research and file, and costs $325, a copyright registration costs. Who's done one? $35. Okay. Copyright.gov. There's a million circulars. If you don't want to do it, you can hire a lawyer who'll charge you too much money. But unlike a trademark, literally all you have to do, the name of the work, when it was published, who's the author, and here's my deposit. It's pretty simple. Now, it's frustrating when you're embodying other works or your parts of it are work made for hire, and I'm making it for a simple photograph, simple copyright for a single work. It's pretty straightforward. It can get more complicated when there's multiple authors involved and there's derivatives and whatnot. But generally, it's something you can do yourself. You should learn how to do yourself, and it's something you must do if you ever want to enforce your copyrights against an infringer. All right. So how do you get a copyright? Anyone know?
Get the form. Fill it out, send it in.
Do you need that to have a copyright?
No.
No. So copyrights accrue as soon as they're fixed in a tangible medium. What does that mean? my presentation right now, me just talking, is it copyrightable? All right, but what about the video of me talking?
Yes.
Right? Okay, so the video is copyrightable. My presentation that is not up here is copyrightable. But me extemporaneously speaking, not copyrightable. So first and foremost, you know, those people who are, those monks who make things in the sand and they're ephemeral, and until someone takes a picture of it, or if it's me talking, not copyrightable. So that's easy. They also need to be original, so you can't take somebody else's work and call it yours, so it has to be original. And it has to have some minimal creativity. So if it's a stick figure or a circle, unless it's some high concept photograph of a, you know, square, then generally you're not going to get a copyright. But 99% of the time, anything you apply for or put into fixed into tangible medium belongs to you. Yes?
When you say tangible medium, if we only have a digital file of that image,
That's a tangible medium.
that is tangible.
And here's a great example. I should have put that in my, well, I didn't pull it up. How many of you are familiar with the Hangover movie? How many are you familiar with the tattoo that's on Mike Tyson's face in the movie? How many of you know that the tattoo artist filed a lawsuit against the movie over a copyright because the movie displayed the guy's tattoo? Okay. One of the discussions in that case was, is someone's skin a tangible medium? All right. Case ultimately settled, but here's a crazy example where an artist, the tattoo artist, put his work on his face and went and sued the Deep Pocket movie studio.
Question.
Yes.
Did he win?
Oh, there you are.
Because I go to a bunch of photo shoots. There's a model, two photographers take a picture of her at the same time.
Uh-huh.
Who owns the copyright?
All right, we'll get to that. Joint authorship is something I'll cover. But let me.
Same photo though, or are they different? Well, you know, different angles. Then they would be the same photo.
No. Well, the simple answer to that is each person taking that picture owns their version of the events that they're covering.
Excuse me, since you brought up the video thing though, if the post I mentioned you earlier also brought the fact about videotapes.
Mhm.
That, you know, if Bob Davis made a video and I copied it, that's violating his copyright.
Mhm.
And if I sell it, I'm violating his copyright. But they brought up that if I rent it, then I'm not violating. Is that true or?
Yes. So let's talk about what copyright law actually gives you. What are the set of rights that a copyright registration, or not registration, just simply creating a work, what does that get you? So I don't have slides, but write this down. The Copyright Office, I mean not copyright, the Copyright Act gives authors, all of you are authors if you take pictures, the exclusive right to make copies of that work, to prepare derivatives, which I'll explain, to distribute copies, to perform it if it's, let's say, a piece of music or a play of some sort, and to display, which would apply to you guys, display the work. So again, make copies, derivatives, distribute, perform, and display. What copyright lawyers do, essentially, is parcel up these rights. When you give someone a license to do something, you're giving them the license to X, Y, Z. So actually, I'll jump into this. So who owns your work when you upload it to Facebook, to YouTube, to whatever, Twitter? Who thinks that the platform ultimately owns the work you upload?
I think Facebook owns those based on the user that come in.
Who thinks Facebook owns it? Who's afraid to raise their hand because they're not sure? Okay. All right, so let's actually read. Let's.
Kind of confused about it though.
How do I come back? Computer people.
It's covered. It's there.
Oh, no. All right, check it out. Can you see that? Let's cover it.
You can focus that screen a little bit.
Can someone else do an example?
Front dial.
There we go.
I feel like I'm in an eye exam. Okay.
The people with 20/50 vision.
This is good.
All right. So this is probably the first time you actually cared to.
No, you can't see it.
Oh, pause. Hold on, my own phone's off. I'll put my phone off. I thought I had. Well, you guys can read that while I put my phone off.
You copyright your ringtone?
Yeah, you could. All right, what does it say?
You give them a
You own
license.
your content on Facebook.
You own all of the content and information you post on Facebook, and you can control how it's shared through your privacy and application settings, which makes sense, because if you own it, that's why you can post it on Twitter and you can post it on all the other platforms. But here's what you're basically saying when you read it. Yeah. For content that is covered by intellectual property rights, like photos, you grant us a non-exclusive, and this goes to the 4 things I just told you about, right? The bundle of rights. Non-exclusive means
Along with everybody else.
you give it to us, you can give it to somebody else. Whereas sometimes if you're freelance photographers for a newspaper, they might say, you can only give us, we're the exclusive distributor of this photograph. Okay, so exclusive versus non-exclusive. Yeah, exactly. And see with royalty free, you guys know what, if you've gone to a stock photography site, whether it's your license is exclusive, you pay more versus it's non-exclusive. Okay. Transferable, that's kind of scary. Sub-licensable, what does that mean?
They can license it to somebody else.
Royalty free,
You can't charge any money from them.
worldwide, to use any IP content that you post on or in connection with Facebook. This IP license ends when you delete your IP content or your account unless your content has been shared with others and they have not deleted it. Practically speaking, once it's up, they're going to do whatever they want with it. Now, the parameters are usually in connection with the business purpose. And every time you see these social media platforms try to push the envelope on what they can do with your content, there's always mass backlash, and then they revise their terms of use and not do it. But it's a good idea if you are, if you're photographers and you care about how your photos are shared, then you need to read the platform's terms of use so that you know exactly what you're looking at. Having said that, does that mean that just because you post something to Twitter, you've lost your rights in the photograph? Who is this giving the license to?
Facebook.
Now, if I like your picture on Facebook and I want to share it, or more problematic, download it to my computer and re-upload it to my blog, have I violated anyone's copyright?
Yeah.
Who says no? Why not? Right. So, well, only Facebook can transfer it, not other people. So this is the big.
We're having an argument back here about someone sharing my photos on their website, and we don't know if that's legal or not.
All right. So did you guys you heard about this case?
Yeah.
1.2 million against who was it? AP? I forget. Yeah. So this guy, Daniel Morel, takes lots of pictures of the earthquake. He posts them on Twitter. Someone else retweets it. AP takes it, puts it into their arsenal of photographs, and lets lots of people license it. Morel gets upset. And basically makes the picture available for sale and redistribution through its various news outlets. Yep.
They stole it.
But then his photo.
It's his photo, but he posted it on Facebook. Here. So he had a deal with Corbis, and Corbis said, "Whoa, wait a second. Why is AP using the photo that we hired you essentially to go out there and take?" And here's some of the photos. You can look up the case later, but the punchline for this one is that just because you uploaded it to Twitter or Facebook does not mean that everybody else is free rein to use it. Now, there might be sometimes an implied license. The problem here was it was reused for commercial purpose. So it might have been less problematic if you were just retweeting it or linking back to it. That's usually okay. But if someone takes that photograph, makes a copy, and posts it somewhere, you've got some issues. Okay. So be careful. Just because someone allows you to embed, embedding and linking, again, generally okay. Even though it serves the same purpose, if you take the picture off and then re-upload it, that implicates a different set of rights, and then you're going to have a problem. Yeah.
So if Twitter has done what these newspapers have done, then would have been okay because there would be, or Facebook.
Twitter is just the platform, so they really need this license to be a business, to operate.
Facebook moves into publishing a newspaper and put the picture, then it would be okay.
They would be okay. Facebook can do whatever it wants with your photos. And actually, every 5 minutes I'm on the news because they're like, Daliah, Facebook's doing this with your pictures, or Daliah, Facebook's, and every time I'm like, did you read the terms of use? It says they own your soul. And they're like, oh, okay. And I'm like, you know, it's really that simple. Like, Facebook's conducting psychological experiments on you. Did you hear that story? They're like, how can they do that? And if you read the terms of use, it says, we can do whatever we want with you. I'm sorry?
Subparagraph 4.
Yeah, right. If you don't like it, don't use it. Yeah.
Now, say for instance that happens, we take a photo, post it on Twitter or Facebook, someone takes it, publishes it in the newspaper.
Not okay.
Do we need like proof, like copyright, something signed to dispute it?
Well, it's your photo, and someone else took it and published it. What else do you really need to show?
Well,
Right?
prove it's yours
Yeah.
if it comes down to it.
Obviously, right. So right, and then there's a substantial. If it's the exact same photo, you just really have to show that they had access, and it wasn't some sort of. But even then, it's easier. The harder thing is, like, we have jewelry clients, and they'll say this jewelry piece looks exactly like mine, and then I'll say, well, if it was an independent creation, the fact that they're both turtles with 6 shells in the back. We have to. Are they substantially similar? Did they have access to yours when they made this? But with photographs, it's a lot more straightforward. It's your picture. It's showing up somewhere else. I will give you a real-world example. I also handle a lot of, how do I say, like movies and really pornography that's shared on the BitTorrent network. Or actually, in this case, there's a pornography company, Chicago, lovely gem, that's called Flavorworks, and they've sued their. So you know them. You're.
No, I'm just like, why are you going into
Well, you seem right. So
because there's nothing original left in porn.
So, but think about it. The pornography studios have been bringing mass copyright infringement suits. Have you heard about this? They're similar to the RIA cases that the recording industry was bringing, I don't know, 8 years ago now. And the cases are essentially this. We've spent a lot of money making this porn that you people love to consume, and now this porn is being shared on various digital networks, and we've tied that to the IP address, ... lawsuit. Different flavor of that type of lawsuit is Flavorworks has sued its own subscribers. What they've allegedly done is put digital watermarks in their videos or their photographs that when they're downloaded by their user, stays with that image. And when that image is then re-uploaded to the internet, it has that watermark, and then they'll say, they're alleging, that the individual who downloaded it with that watermark is responsible for then the later distribution. There's an example of a case. And we've been fighting the fact that, oh, your watermark's bogus, just because he downloaded, his computer could have been, someone else could have gotten it from different places. We're challenging the chain of title between this alleged software that puts the digital watermark. And I'm not talking about one that's on the face of the video. It's embedded in the code. Anyway, but the point is, you have to show that, yes, they took it and they distributed it. Okay, what else do I want to talk about? So the next question is, so you've decided, so this happens. Most people take pictures and they upload them. And if someone infringes, someone takes that picture, what can you do? Can you do automatically? Can you immediately go out and file a lawsuit?
I guess you can try, but you should ask them to stop it, or?
Yes, you can file a lawsuit, but practically you ask them to stop. But let me say this, you cannot file a lawsuit if you don't have a registration. So most of the time, photographers who are amateurs will call and be very upset about the fact that their photograph is somewhere else. And my first question is, do you have a copyright registration, or have you even applied for one? Absent that registration, I physically can't go to the courthouse and file a copyright complaint. Yes?
I thought if you just put in your metadata, or when you posted it on Flickr or Facebook, you put the copyright sign and the date or the year and your name. Doesn't that give you a copyright?
All that does is put the infringer on notice, so then when you do go to sue, you can ask for heightened damages because the infringement was called willful. It's quote-unquote willful. But no, it's statutory. In order to file a lawsuit, you need to have the registration. More importantly, copyright law is one of the only areas where you can actually get your attorney's fees, and there are predefined statutory damages. What are statutory damages? That means, what is a picture worth? Let's say someone takes a picture of my daughter that I posted to Facebook and reposts it, and I don't like that. I would sue for copyright infringement. What's the value of that image? What? Maybe she's really beautiful and she would have a modeling contract. I don't know. But very hard to define what that is. So the Copyright Act says if you register within 3 months of publication or before infringement, so the timing of the registration is also very important. Then when you do go to sue, and if you are successful, you can not only recover statutory damages, $750 per infringement up to $150,000, which is why you saw the big numbers with the recording industry cases when those were being filed, but you can also ask for attorney's fees. So you should make it a habit to register collections of works or single photographs if they're fine art pieces or whatever it is on a regular basis. It's $35, it can start accruing, can be kind of expensive, but it's the best insurance for a photographer if that's their business. Yeah.
So if you're photographing a wedding,
Yeah?
copywriting the entire shoot?
Yes.
Or are you copywriting each individual?
You can copyright a collection so long as they're published as a collection. But you can't then go and you arguably could not then register a whole year's worth of weddings unless you're calling them here's my book of weddings that I did for.
2014 collection.
Right. You can try, and really then we would just knock it out on a case-by-case basis to say what does it actually cover.
Unrealistic.
If it's a collection, you can copyright a collection. But you have to show that you have to show that they were created as a joint, as a collection, not as disparate photographs.
If you don't register it, you have no claim.
If you don't register, you can't file a lawsuit. It's that simple.
Can you complain the same way if a photo is taken and used for commercial purposes or for editorial?
Doesn't matter how it's used. Unlike a right of publicity claim or other things, I'll cover fair use as well. How much time do I have to talk? Because I can talk for hours.
4 days.
Okay.
I'd have to talk to it.
Just,
Well, the sun
We have
comes up.
another hour and 45 minutes.
all right.
Yeah, you have plenty of time. You can go another.
Just want to listen to me talk. Okay, yeah.
It was fascinating. You should-
Obviously, you talked about social media. It sounds like it's different though than if it was taken from, say, a website. Like if it's on one of our own
No,
websites.
not different.
Well, if somebody downloads it off of or copies it off of one of our websites.
Yeah.
We don't have the same terms like Facebook had saying they own your soul. So if somebody takes it from your website, it's no different than if they took it from Facebook.
No different.
I agree with you.
Because remember, this is just between you and Facebook. It's not between someone else who takes it off of Facebook. Yeah.
What about Pinterest? Don't they take it from people's websites?
Pinterest, huge backlash when people were really worried about their images on Pinterest. So Pinterest is a platform provider. Their position is that despite the fact that we basically tell you to go infringe on people's copyrights, we are merely the platform provider. Now, if you notice, there are 2 ways to post to Pinterest, right? You can pin. What is pinning do? How many of you are on Pinterest or have Pinterest boards? Okay. You tell me, how do you make a board?
Either I'm already on Pinterest and I look for something to pin, so the picture's already there. I just repin. If I happen to go on somebody's website and they have the Pinterest logo, they're allowing me, hey, go ahead and pin this to your board.
Okay. So there's 2 ways to. You guys know what Pinterest is for the people who are not on Pinterest?
Can't you also upload your own?
Yes. So you can either link to an image, pin it, and pinning essentially is linking to an image from another site, or you can take your own images and directly upload it. To the extent you're directly uploading photos, you must only upload your own. So if it's easier for you for some reason, or you don't see the pin button, then you don't want to take that image off someone's site and then re-upload it. You've definitely committed copyright infringement there. If they have the pin logo, they're basically subscribing to the concept of people pinning, and most of the time, photographers will not want their stuff pinned, because that's unless they're selling other services like their actual wedding photography services, fine. But if your business is selling the images and someone's repinning them to Pinterest, you're going to have a problem. So maybe as a photography society, you're like, oh, check out Bob's awesome photos. You think you're doing him a favor and you're giving him some publicity. He may say, no way, I only want people to see my pictures on my page so that they know how to contact me easily. Because Pinterest is like you can go into a deep hole and not know where the origin of it is. Let's look at something prettier while we talk. Let's go to the monkey.
I have a question about copywriting collections.
Yeah.
This is a good story.
Yeah. Sorry, but
Yeah.
Is it the same cost to copyright a collection?
yes, it is. Okay, so who is the author of a work? Whoever creates it. So if who's the author of the video that she's taking of me talking?
See your camera out.
I'm doing all the work though.
So she's doing all the work of taking the video.
Okay.
She's recording.
She's affixing it to the tangible media.
Crazy, right?
Yeah.
Well, and she's also authoring how the camera's positioned and all the rest of that stuff.
So this brings us to the monkey. Who wants to tell me what the monkey case is about?
Photographer.
Go ahead, tell.
The photographer set up his camera in such a way that wildlife could trip the shutter and take photos of itself. The photographer claims that he owns copy.
Wait, before we get there though. The photo got to Wikipedia, and Wikipedia posted the image, and then the photographer.
Okay.
Go ahead, Michael.
Right, so the photographer claims that it's his image, okay, and the monkey claims it's
The monkey was out of it.
So animals taking pictures cannot own the photo, so it's public domain. That's the punchline. But for your purposes, this becomes really important. The concept of what's called a work made for hire. If you don't remember anything else I said, you need to remember this. This is the source of most disputes and litigation when it comes to photographers. Do you guys know what the phrase work for hire means? Not in general, but in the context of copyright.
No.
All right, let's do it by way of example. I need some photos for my website. Who would like to give me some photography services?
Here's a real world example.
okay.
You bring a second shooter to a wedding.
Yeah, let me do my example. Then we'll go to your section. Okay.
All right, well,
I was in my groove. All right, so who's gonna provide my photography services?
I am going to do it.
You're gonna do it for me. How much do you charge? $1 million. I think you're worth it. I think you're the best photographer, and you have charged me $1 million.
I'll do
Okay.
it for $950.
Okay, so we meet here. You show up at my office. We take some beautiful glamour shots. Thank you, and then we post it to my website. And I decide I don't really have $1 million right now, so I'll send you a check. And a few months pass, and you're like, where's my money? So, who owns the pictures? Who's the copyright owner of the images? Well, hold on. I actually found some money, and I got it, and I just paid you the whole $1 million.
I didn't give you the full copyright.
Well, we don't have an agreement.
I did, oh.
We just have a verbal agreement. You came and took the pictures. I actually did end up paying you. I'll take it back. I gave you the whole $1 million because you are worth it because you're so good. So I paid you the $1 million. I have pictures. Who owns the pictures?
Who's on the photographer?
Who says I do because I paid $1 million for them?
But you didn't create the work.
Didn't Oprah lose a case like that?
I don't know about Oprah, but
Did you file a copyright registration?
hold on. We're keeping it simple because in real life, no one files anything or signs any contracts. Okay, so this is the phone call I get.
I would say the person that paid for the pictures.
Person who paid $1 million.
Absent an agreement, the photographer would retain the copyright.
Says the lawyer and president of the Chicago Photography Society. His answer is correct. So all of you, absent a written agreement, are by default the owner of the photographs you've taken, even if you've been paying $1 bazillion million. Okay. So your second shooter is probably not your employee. He's your buddy who's helping you because you have a gig and you need some extra help. So under that theory, who owns the pictures taken by the second shooter on the job that you found and you've procured and who is your client?
Because we're members of CPS and we're all smart enough to do it, having listened to Gokon's presentation.
I don't know who that is.
He was our past president.
Okay.
We all have written contracts with our second shooters that they are working for us.
And now we've
Give
got the
alongside.
concept of the work made for hire doctrine. So the work made for hire doctrine is as simple as that. The Act enumerates certain categories of works that are considered would fall under what's called a work made for hire, and one of them are collective works or things like that, things like a shoot. And you need a written instrument, a piece of paper that says, when I hire you as a vendor or a freelancer or an independent contractor, then despite the fact that you are a vendor, a freelancer, or independent contractor, and despite the fact that I pay you for your services, the work is being commissioned as a work made for hire, as that term is defined by the Copyright Act. To the extent for some reason what I've hired you to do doesn't neatly fit within the categories enumerated in the Copyright Act, you hereby assign to me all rights and interests in the work product. It's that simple. So absent that piece of paper, we get to make a lot of money, lawyers, because then you're fighting it out. Now there is some caveat. Well, okay, so that covers work for hire. Now the other layer to that is if you're employees of an organization, there needs to be no written agreement. By default, the employer owns the work product. So how many of you have day jobs? And how many of you, how many of you are in creative fields as your day job? What's your day job?
I'm a designer. I'm going to be doing what you explained next week. I'm shooting for my boss for a website.
Uh-huh.
But, you know, do I own my images or does he own my images?
What's the answer?
Boss.
Your boss owns the images. He doesn't need to make you sign anything. Now, here's a wrinkle on that. Your boss, your employer owns what your work product is, so long as that work product fits within the scope of your employment. So your day job is you're a designer. I don't know, what do you do?
Graphic design.
You do graphic design. And who do you do it for? What kind of clients do you guys have?
We have a sugar factory that
I mean, you're just like general graphic design services for all kinds of businesses.
Yeah.
All right, so let's say at nighttime you have a hobby and you are composing some music, because you're also really creative and you like writing songs. Does your employer own your songs?
No.
Why not?
Not the content.
Doesn't matter if it's off work hours.
Not part
not
of the
within
job.
the scope of his job.
The answer is it's not within the scope of his employment. Now, let's say at nighttime, your buddy asks you to do a logo for him, some graphic design services. Who owns the graphic design services for your buddy?
Even if he's a freelancer and he has his.
No, he's an employee.
Oh, okay, so you can't do it as an employee.
What if I freelance for that?
Well, arguably, your boss would say that graphic design services are within the scope of your employment, and just because you came up with a side gig or deal doesn't exclude that service from what he gets to own.
What if he has applied for a business license? What if he's applied all the right avenues to have business?
Usually, this comes up a lot with software developers, because most software developer clients I have are coding something for fun on the side. It's a conversation you have to have up front and have something on a piece of paper that specifically states, I have this side gig, I have a side project. Employer, please clarify that the stuff I'm doing on the side is mine and not yours. Yeah.
Does it matter as far as terms, full-time, part-time, if you work for
No.
someone occasionally?
W-2 employee, doesn't matter. If you're a W-2 employee, the work that you create within the scope of your employment is owned by your employer.
1099 employer?
Are independent contractors, and then you own their own work.
So they
Correct.
would own everything.
So photographers for the Tribune or the Sun-Times, the newspapers, so the.
If they're employees of yeah.
Yes, as a matter of fact, a couple of local papers, the photographers actually quit to go off. They could pursue teaching. Alex Garcia.
What about Scott Presante, too?
Well, Scott's actually in the newspaper, so that new newspaper I was in.
But he was an employee. He was an employee when he was here.
Right, so then the paper here was showing the images that he shot while he worked for them.
Right, and he mentioned that in his presentation, that he was aware that they owned all his images. In fact, they were selling his images
Right.
in an online store that he didn't share it.
Yeah, Alex was complaining because he actually had been approached several times for books and he couldn't use any of his images.
Very good information.
Okay, so now anything else about work for hire? Okay. So the other issue becomes, yeah?
Yes.
Okay.
If, for example, I set up background lights and everything, and I stand as a model, and I ask a bypasser, push the button only.
Great. It's like I staged that. That's so great. All right. Okay.
She was modified.
Oh, hold on.
By the way, everything he's doing, since it's on my computer, I now own.
Everything what?
Is that true?
I didn't hear that.
Everything you're doing is on my computer, so I now own it.
Yeah, but I'll come after you. I know a good lawyer. Okay, so, all right, this is your question, right? This post, we posted this to our website, and we got a bazillion retweets, and the picture itself got, 2 million retweets, right? So the concept of joint work, before we go to the selfie phenomenon, which people are obsessed with. Let's talk about what a joint work really is. And oftentimes, this is another way that disputes arise. I get the phone call where, hey, I hired this photographer to do stuff for me. I told him what the photograph should look like, or I told him to come take pictures of my products. He came and took pictures of my products. Now he's not giving them to me, or whatever the dispute is. What can I do? So you have to see whether or not you're a joint author. Joint authors, there's two elements essentially that the court will look at to determine whether a photograph constitutes a joint work. And those are essentially whether or not you intended for this to be a joint work. Okay, did you, and a better example is, I have a comic book idea, and I write the story, and I hire, Jerry? Jerry.
Yes.
Okay. I say Terry or Jerry. Okay, I hired Jerry to do the illustrations. And I
No kidding, that would be the worst idea ever.
maybe it's a photo comic.
That's the stick figure copyright there.
Okay, so essentially, and we talk about it, and we're like, all right, we're going to create a comic book. I'm going to do this, you're going to do this, and it's going to be our project. Or maybe there's no words. Maybe I just give you the idea. Like, I want you to take pictures of, trees and cars and put them in this order, and you do all the pictures. And so the final product only has your pictures, but I told you what to do. That could be a joint work. On the other hand, there's cases where a business owner had someone come in and take pictures of their clothes, of the dresses. That's another case which I have in the presentation. And there's a dispute, and the photographer's not giving up the pictures, and one of the causes of action is, hey, I'm a joint author in that work, I'm entitled to the image. And then the court will say, well, you didn't intend to be joint authors, you just hired the photographer to take pictures of your stuff, or you hired the photographer to come to your wedding. Are you a joint author with the photographer who takes pictures of your wedding? No, I mean, you told him to be there and you told him to take pictures of you, but you didn't frame the image, you didn't tell him when to take the image, you didn't tell him what should be in the image. So this was kind of a big debate, like who owns the Oscar selfie? Is it Ellen, because she got everyone in to get in the picture? Is it Bradley Cooper, because he actually took the picture? And no one really, there's no case, so we don't really know, but there's theories. Like some people say it's only Bradley Cooper, others say it was a joint work because, Ellen organized it, others say this was all a stunt and Samsung or the Oscars own it because they employed Ellen to do it for them, and then you can read the article, we kind of go into the different theories in more detail. Yeah?
I'll go back to your wedding. Well, most wedding photographers will know, what about the shot list? The bride wants a particular shot and you get it.
Arguably, she's just telling you what things she wants covered, but she's not, again, helping you stage each picture.
I want like makeup artists, the hair people.
It could be problematic. But again, did you intend to have a joint work? They're just helping you with the photo.
Right.
And it gets very mushy, which is why you need contracts. Contracts.
So what about her question when she says, I'm the model, I set up the camera?
So arguably, you directed, you told them what to do, you gave the direction, but it wouldn't mean you own it. You'd still be a joint author.
Even though she owns the camera, she owns
That's the monkey case. I mean, it happens to be the monkey, but yeah. She's taking the video, right? It's of me. And we all already agreed that she's the one who owns the video. But I'm the one in the pic. I'm the subject matter of the picture.
You don't own the camera, right?
Doesn't matter who owns the ownership of the device used to take the image is irrelevant.
really.
So basically,
I mean, it could be a factor in whether or not you intended but
Steal your iPhone.
So how about in a case where there's a model, and she's looking for a very specific look, she even tells you how she wants you to set up the light.
So then that would be a joint work. Those are the different. It's a fact-based determination. How much input was there by both parties, and more importantly, was there an intent for them to cooperate to create a work? Here's a real big problem with joint authorship. What are the duties? Well, I'll give you. So we talk about intellectual property, right? And the reason we call it property is because the ownership in this stuff mirrors the property laws for real estate. When we talk about licensing, we're saying you can rent. License is renting. You can rent my picture for a year, so you can put a geographic, put a time restriction on it. You can only, you can't paint the walls, so you can't make derivatives. You can't sublease. You can't sublicense, right? So similarly, when we're not talking about renting but owning, how many of you own a home? Great. How many of you own a home with a spouse or someone else? And how do you own that property?
Joint tenancy.
What does that mean? What does joint tenancy mean?
Equal rights.
Can one person sell 2 rooms in the house? If you have to sell the house, you have to sell the whole house, right? Okay, similarly with a copyright, joint authors can each sell the work. You can't sell half of the work. And you don't need to ask permission from the other author to exploit, to sell that work. So if you don't have contracts, you could be in a situation where the work is deemed to be considered a joint work, joint authors, and we take a picture and I'm like, oh, I'm going to take this to Jerry Springer. I think he'd love this, right? I'm trying to think of something that no one would like. Okay, so, or maybe you love Jerry Springer, but the point is it's something that may muddy the reputation, and you don't, as an artiste, you don't want it to be on a show like Jerry Springer. Can the other author stop the joint author from distributing that work somewhere they don't like?
Not if they didn't have it in writing.
With absent agreement, no. Your only duty to the joint author is to account for any money that you've earned, and you have to give them their pro rata share. 50% if you're joint, 30% if there's 3 of you, whatever it may be. And then we have a lot of cases about that where we're trying to figure out what the ownership is and whether or not the person actually paid him for the work. And band disputes often look like this, yeah.
Is it the case that most of the people that come to you don't have contracts?
Of course, yeah.
That's the case?
Yeah.
Otherwise, if there was, it's
Why
much
she's
simpler.
successful and has this huge website.
Yeah,
That's
yeah,
right.
that's-
Huge,
that's an
huge
interesting
website.
point.
I mean, even with contracts, and you can always argue, but of course, if you've taken the time to put a piece of paper, something on a piece of paper, you've considered and thought about these issues.
Right.
So a lot of this ambiguity, whether it's a joint work, fact-based, whether, who owns it? Did I direct you to take it or not? Fact-based, yeah.
Can you specify something like that to the extent of if one of us did work with, say, hair or makeup artists, we were allowing them joint ownership, but could we just specify to say you can't change anything? In other words,
Sure.
you can't take the image and
And a license, just like a rental agreement. You can paint the walls blue, but not yellow.
You
can pay. Yeah, you can't share on whatever. Okay, so actually, do you need to pay a lawyer to draft really awesome licensing agreements? Not necessarily. I mean, if it's really important, you probably want a real lawyer to do it. But if you want to, if you have just a lot of pictures, yeah. If you want, if you have a lot of pictures and you're posting it on Flickr or online, and it's not like for money, or you just want to control how your stuff is used, then you can use the Creative Commons license. Are you guys familiar with Creative Commons?
No.
yes.
I said no. Where do I see this?
All right, creativecommons.org.
Excuse me, one more question on the last image.
Yeah,
Do we need to get model releases involved in that as well?
I will cover that at the end.
Okay.
Who knows what Creative Commons is? Who uses it? Tell us everything.
Everybody in here, but I didn't know.
Go ahead. What is the Creative Commons license?
Well, at least in my use case, I've used it for some of my images on Flickr. I guess that kind of outlines it.
Well-
You have different types of licensing for different distribution methods for a specific image. So like when I was getting started in photography and I just wanted to share what I had, I maybe had like an attribution of derivatives.
Okay. Did we ever cover? Did I explain what derivatives are? By the way, I feel like I didn't really explain what that is.
Painting the walls yellow.
No. So a derivative is essentially, and it plays in when we talk about fair use. If I write a book and someone wants to make a movie based on my book, the movie is a derivative. If I write a poem and someone wants to write a book, the book is a derivative of the poem. If I have a song and someone wants to make a movie or whatever, or do something else with the song, anything that you build on that uses the core underlying work is a derivative. Now, who owns the derivative? If I license the right, or if I use the song or make a movie based on a book, who owns the movie?
Producer of the movie.
The person who made the movie. They can own the derivative, but they can't sell or distribute or do anything with that movie without permission from the underlying owner. To make the derivative, you need permission because only the owner has the right to make the derivatives. So that's something to think about. So the Creative Commons licenses are these little widgets that you can use. It's an open source concept. Open source means like, we want to encourage people to share, and we want people to have control over what they want, how they want that stuff to be shared. So you can have an attribution license. So, hey, anyone can distribute, remix, tweak, build, do anything you want with my photograph, as long as you just give me credit. All right, anyone can use my picture, but they can't do it, don't mess with it. So give me credit, no derivatives. Don't change it, don't color it. Attribution, non-commercial, share alike, okay? So you can credit it, but you can't then, you have to credit it, you can't use it for commercial purpose, and if you're letting other people use it, they have to be able to do the same terms. And so there's a whole bunch of these, and you can look and read through them, and whichever one you like, you can attach to your work.
Do you buy these or what?
Free.
It's free, it's open source.
It's free. Yes.
Attach the logo or?
Yeah, attach the logo. And Flickr will often give you the option to click the one that you want.
You attach it to your metadata, or you actually put it on the...
You can put it on the image, near the image. Like this, and you'll see now you'll look at that phrase. This picture is shared under the Creative Commons ... license.
When you upload a picture, it will, on Flickr, it will give you the option of whether you want it full copyright, public domain, or one of the 6 licenses.
Yes. So I'll jump to your model release question, and then I'll go backwards. Yeah. Oh, go ahead. Wait. Yes.
Just before we move on from that, just one other question. Many photographers, including I'm sure people in this room, hire retouchers to do work either on bulk images or on a more extensive work on a specific image. Absent a specific agreement as to copyright, is there a point at which the retoucher may gain ownership over this as
a joint author? Yeah. That's why you want contracts.
Let's say I originally uploaded an image to Flickr on under one of the Creative Commons licenses. Can I then change the license to a full copyright? And what will that mean for people who've used it before the copyright?
It won't apply retroactively.
Okay, so anything from the date the copyright was set on is copyright.
Yeah.
Okay, thank you.
You're welcome. Okay, so let's talk about models and model releases. So this is a great example of a Flickr photographer using the attribution only license. Okay? You can do whatever you want with my picture.
Just say it's mine.
Yeah. In fact, I don't even think he had that. It just use it. I don't even need attribution. He had the blanket. I don't care who wants to do whatever you want to do with it. Do with it. No one cares. So can you see that picture? Yeah, you can kind of see it. Okay, so Virgin Mobile decides it wants to do a campaign for its new mobile-to-mobile network. And they decide they're not going to pay a fancy ad agency. They're just going to use a real person to be the poster child of their ad campaign. So they direct someone to go on Flickr, and they find this really random picture. Does it look like anything special? It's like a pretty poorly framed, nothing going. And so the photographer was probably just like a Joe Schmo like me and like anybody who uploads their bulk album from church barbecue and says, whatever, who cares? I want all my friends to see it. I don't understand what this means. Anyone can use it. Okay. So Virgin says, this is a image that has no copyright restrictions. Correct?
Correct.
Who says correct? You say no, why not?
Because technically the person who took the picture has...
But he said you can use it.
Oh, okay.
He told you explicitly that you can use the picture. Right. I'll tell you the answer. No copyright issue. So we just saved ourselves lots of money.
How did the author of the picture say you can use it?
When you upload to Flickr, you can click that button.
Oh,
it's a button.
okay.
And so when you look at the picture, you see what the restrictions are on the image, and there are none. Yeah.
However, what about our...
So one day, Allison Chang gets a friend an email who says, did you see that you're like in this tweet with this picture of an ad campaign that says, dump your pen friend virgin to virgin, mobile to mobile? She's 15, which also doesn't help matters. And she's really not so excited by the fact that her now image is being used all over Australia, is actually where the campaign was, and she brings a lawsuit. Does she bring a copyright infringement lawsuit? What kind of a lawsuit can she bring?
Defamation of character.
Maybe. But you're really defaming her? Is being called a virgin something that's defamatory?
There was no model release.
Okay.
And she's a minor.
years old.
All right, so the law that's implicated is a misappropriation of your right of publicity. This is the law that governs how all of us as individuals can control the use of our image for what's called a commercial purpose. And they've got a lot of questions, and I saw it on your Facebook page as well. If I'm out taking pictures of people in a park and I post it on my website, am I violating anyone's right of publicity?
Good question.
No, not a misappropriation.
I want to answer.
No, unless it's,
So right of publicity is a state-by-state cause of action. Some states have actual statutes that govern whether or not you can take someone's picture, and others rely on common law torts. But essentially, all states and all causes of action are as follows. You take someone's picture without their permission, and you use it commercially. You use it to sell something. So a lot of the litigation governs whether or not the use is truly commercial, or if it's newsworthy, or if it's just, like if it's not promotional, if it's just something you're posting that's not directly selling anything. So if you have an exhibit where you're just taking pictures of people in the park and you have, a show and the whole exhibit's comprised of people in the park, is that a commercial purpose?
Are you
If
selling
you're
them?
selling them.
You're selling them, you're selling the prints.
No, it's not a commercial purpose.
Not really a commercial purpose. There's been lawsuits over that, actually. And so generally, if it's just a news story or, the question is, does the fact that your face is in it help sell whatever it is you're selling? If it's usually a product, then you've got a cause of action. Do you need to be Kim Kardashian to bring this cause of action? No, you don't need to be a celebrity. Certainly celebrities have endorsement deals. People want to buy their images, but you can be a Joe Schmo and you don't want your picture on, orange juice cans to sell orange juice. So this is the exact case. I mean, she didn't permit her face to be she didn't want to be the poster child of Virgin Mobile's campaign. The case was dismissed for procedural reasons, but it's a good example of someone thinking that they're doing the right thing. They didn't violate anyone's copyright, but they had this issue. Yeah.
Could she sue the person who took the picture
For what?
for her thinking that she didn't give him permission to upload?
Well, he's not the one who used it for a commercial purpose. No.
He's the one who uploaded it.
Yeah, now, let's say they're in a therapy group and they're in a small, intimate setting and he takes the picture and posts it. She may have an invasion of privacy claim, which is totally different than this. Yes? Yeah, go ahead.
Sort of in the fine arts realm. So if you take a picture, you're in a public park or on the street somewhere or traveling somewhere and you take someone's picture, you can sell it yourself as fine art, but you can't use it in some sort of a campaign. Is that what I...
Yeah, you can't use it to sell your photography services, arguably. Then it becomes a gray area. But if it's just as part of your collection, that's fine. But if you're saying hire me, and then here's this guy's face, then you've got a problem.
Even if it's part of your website
Again, that's what lawyers make lots of money fighting about.
the gray line.
Yeah. I mean, it's obvious if it's, hey, here's Daliah's face on this bottle of water. That's clearly, Tiger Woods is on this piece of, this stuff. But it's more ambiguous if it's just a series of things or, it's one of many images.
So I'm uploading my pictures on my website and somebody from a bridal party, she's in there, she sees it.
Clearly that's more of a portfolio piece. You haven't focused in on that person to sell your stuff.
Well, I'm selling my business, so I can't be sued by this.
You want a release because you don't want the ambiguity. She would argue, come on, I'm so awesome that this is the picture. This picture of me at my wedding is what's selling your services. I didn't.
So she could try to.
She could try. I don't think she'd be as successful as you handing out flyers with her picture on it and your logo. That's a little bit more problematic.
So if in a model photography situation where there was no exchange of money, but it was done trade for service, both the photographer and the model knowing that they were able to use the images for self-promotion, i.e. portfolio.
How do I know what she thought?
No, that's written down in
Oh, in a piece of paper? Then you have a release. That's what model releases are. Model releases say you can use my picture for a commercial purpose.
But then if I wanted to later on turn around and create a book of all my photography and her pictures in there, I could still do that, okay? Because she's not technically being used to advertise a product.
Right. Right.
Now, if the publisher of the book decided her photo was the one that was going to be used in the ad, to
Then that's a
somebody,
problem.
That's a problem.
Or
Right.
the cover art.
Right.
So you can go back and try to get them out. So
Yeah, so model releases are good, especially with photography contracts that we draft. We'll have a provision that says we're going to use your picture on our website as a portfolio piece and to, to market our services.
So about a situation like this with a group meeting, Jerry's taking pictures for some reason.
Yeah.
You'll probably could probably post them on the group site saying, hey, we have great classes,
yeah.
seminars, come join us. Is that a weird area?
Probably
We
fine.
should have a
Probably fine. I mean, like I'm the kind of lawyer who's like, if it doesn't pass, if it passes the smell test, you're fine. Like, someone's gonna be a real asshole. Excuse my language. If they're gonna call you and say, I didn't want you to take my picture when they're sitting in this room at a photography, seminar, and they see everyone taking the pictures.
Now, what if we go to the next level and our company uses it to say, hey, we support the community, we have meetings?
Then the defense would be that the person's picture it's a nominal use, it's a fleeting use, it's not the focus of the picture, you can't really identify the image, and that specific person is not highlighted to sell your services.
What if it was a picture like you and I talking?
Same thing. I do it all the time for my website. You go on my Facebook, I've got people's pictures all over it. But if I suddenly say, like, check out Bob, Saper Law client, like I'll show you what I do on my site. So I did this with my clients, some of my clients, and I have videos of them saying how great we are. And, they are selling and they're okay with it. I've gotten their permission. But general pictures are fine. Again, if you're honing in on one person, or you really highlighting that, then you could have more of a problem. Yeah.
Back to the Virgin advertisement. While it was dismissed, did Virgin take down the ads they had up there?
Well, good question. I don't really know. It was in Australia, and it was dismissed for procedural reasons. So I don't know the answer to that.
Okay.
But
Fair.
damage has been done. It doesn't really matter. It was already up for a period of time. Okay, I talked about photography. I've talked about almost every. Oh, what I haven't talked about is the concept of fair use. And I think that's my last. I'm going to end on that note. All right, so fair use. What is a fair use? You guys are familiar with this case?
Yep.
All right, so did you know that this poster is based on this picture?
Yes.
Who did not know that? Okay. Who took this picture? Who owns this picture? AP. And who did that picture?
Shepard Fairley.
And who is Shepard Fairley?
One of the artists.
Yeah. So he takes this, he makes that, sells it. It's wildly popular. AP says, what are you doing? This is our picture. You didn't get a license. This is a okay, derivative. That's what AP says. What does he say?
It's an original work of art.
Well, there's this concept called fair use. Now, what's public domain? People use those phrases interchangeably. What is public domain? Public domain refers to works where the copyright has lapsed. How long do copyrights last? 70 years after the death of the author.
How many years?
70. Or, it depends on what, 70 years past, for your purpose, 70 years past the death of the author, or 120 years after the work was created, if the work was created under, as a company, under like a work for hire situation. And by the way, that keeps extending because of the Mickey Mouse situation. You guys know this? Okay. No. Every time Mickey Mouse comes up for expiration, Disney lobbies and they get it extended. The last one was in the 70s. Because can you imagine Mickey Mouse being a free-for-all? I mean, that would really impact. So then public domain is free. Now, fair use is what people rely on most of the time, not correctly, to state that even though something is technically copyright infringement, there's some overarching reason to allow it. either a First Amendment right to make a commentary, it's satire, it's a parody, I'm doing it for educational purposes and non-commercial. And so it's, even though it's technically not, technically infringement, it's okay for some other reason. So one of those other reasons, and then it's also very mushy, it's very fact-based, and a non-exhaustive list is as follows. If I can find it. Oh, it didn't cover DMCA either. Well, how much time do I have?
You have time.
Okay. All right, so when a court analyzes whether something is or is not a fair use, they're going to see what was the nature and purpose of the use of that work, what was the copyrighted work, what's the nature of the work itself, how much was used, what was the amount and substantiality of the use, and what's the effect on the market of the underlying work. Those are some of the factors. This allows people that, because of this, people think that if you use 5%, there's a 10% rule. If I only use a little bit of something, then it's fair use. There's no bright line rule. You could use a whole thing, and it could be fair use. You could use 2 sentences of an article, and that could be copyright infringement. So in this case, he's arguing, well, this use is fair use because if it's not derivative, it's transformative. By putting pictures on it and putting the words hope on it, I've transformed it or made some sort of new commentary on it. Do you guys buy that? It's pretty much a derivative. He's just colored it.
Yeah.
Okay, so and I have another one of my clients.
So what prevailed here? What happened?
He lost, I think. I think they said he lost, and then he appealed it. Yeah, he did a lot of shady things during the course of litigation that didn't help him. But I'll give you a better example. So this is one of my clients.
Are you violating client attorney privilege?
Nope.
by showing this?
Nope. I'm giving them lots of free publicity.
Okay.
Okay, so here's something that I do for this client. By the way, you guys should buy. They're a Flash T-shirt site that's crowdsourced. All their designs and art come from the artists who submit. So they're not actually making anything. The people upload and then they pick them. Now, if you look at some of their pictures, let's find a good one. You'll notice that a lot of their stuff is mashups of different properties.
Dr. Fu and 2001. Mario.
I see. So some you can funky.
Okay, you get the idea?
So they don't have the real name. It's almost like garbage pail kids.
So they're using Ghostbusters in...
All sorts of issues, right?
Yeah.
Okay, so they make a calculated risk based on what we tell them the risk profile is. They don't listen to me half the time, but their entire business is premised on mashups of pop cultural references and properties, and we get takedown notices all the time. Marvel and Fox are like, you're using Teenage Mutant Ninja Turtles and Harry Potter in one, take it down. And every time our response is, we disagree that it's infringing because under, it's transformative. We're making some public comment. We're making a commentary about how ironic it is to combine, Ghostbusters and whatever it is. And it works some of the times, but most of the time we just take it down and they go away. But here's an example where we're trying to make the argument that by mashing up different things, there's some sort of other commentary we're making, so therefore it's okay. I would not rely on fair use if I were you, because if you're at that point, then you're basically you're defending federal litigation, which is no fun. The final thing I'll talk about is the DMCA takedown notice procedures. You guys familiar with that? All right, so you have taken a picture and someone posts it online without your permission. What is the fastest way for you to get that image off of the internet? Can you sue YouTube or Facebook or Twitter for the picture being up without your permission?
You can try, but
So YouTube is protected under the Digital Millennium Copyright Act, so long as they register with the designated agent with the Copyright Office to field these types of questions. All of you should become familiar with it. Another thing you don't need a lawyer for. So you'll go, all of these sites, if you look up DMCA, I pulled up a couple. So here's Facebook's. No, where is it? Here. So copyright report form, I found content which I believe violates my trademark. I found content which I believe violates my copyright. Here's my contact information and my phone number, ... I submit. Here's the one for Twitter. And it'll tell you. You basically tell them your name, the link to where the stuff is located. Sorry, I won't stand for it. And actually I have a better one. Here's Pinterest, actually. Here's the best one. So identify your work on your own website, identify the infringed work on Pinterest, your full name, and that's it. Cheaper than going to a lawyer to do it for you, right? Okay, so what happens once you submit this is the notice goes to the individual who's uploaded it. They have 2 weeks to respond with a counter notice. And if they don't, then the site will take it down. If they do, unless you file a federal lawsuit, the site can put it back up again. And one of the best examples of a DMCA takedown notice is, it's not a photograph, but it is, I should have pulled this one up as well too, is the Prince YouTube use.
And you can do that regardless if you have a copyright or not.
Yeah, I mean, you have to say that you owned, that you are the rightful owner. If I can find this video. Here we go. This is like a 3-year-long lawsuit over this 30-second video. Riveting, right? Okay. Prince, takedown notice.
Get out. Oh.
And this video has my song. I didn't tell you, you didn't license the song for use with your video. Take it down. Simple as that.
Obviously it didn't work, it's still out.
Well, so she filed a counter notice and litigation ensued. They filed a lawsuit. So you can look that one up for fun. But basically, it's a very fast and efficient way to take down stuff if the person doesn't respond.
How did Prince even find it?
Oh, there's all sorts of rights management stuff that you can use to match.
Prince probably didn't do it some opportunistic individual.
No, it has to be the.
No, but somebody could alert him.
Oh, yeah.
Yeah.
Who knows? And that's I'm done. That's all I got for now. Did you have another question?
Yes, you showed us that takedown notice on the websites,
Yeah.
Facebook, Twitter, and Pinterest. What about like other sites?
Most sites, any site that's a platform provider, in their terms of use, somewhere will have a copyright agent, and then that's where you submit the notice.
What about international?
Doesn't apply internationally.
Okay.
Good luck with that. Yeah. That's my contact info if you want to get a hold of me, saperlaw.com.
Can I throw one more question at you?
Sure.
Suppose, and we talked about the right of publicity for people, like for non-commercial use, taking a picture in a park or whatever. Suppose someone in this room takes a picture at a wedding. It's a private event and private property, and they get like a big group shot of all these people together. And then, or maybe it's the bridesmaids or whoever. And then they take that photograph, and they have a contract, let's say the bride and groom, that gives them the right to use the photographer. Photographs for marketing purposes, et cetera, et cetera. Are there any circumstances under which the people in the photo who were not party to that agreement would have a claim for a violation of the right of publicity?
Yeah, if you're using their face for commercial purpose. Same thing we just talked about. Anybody's face, anytime you use someone's face to sell something without their permission.
So basically contracts are stating that I can use the bride and groom's face?
Yeah, you can't get, unless you put a sign at the door and put people on notice. This wedding is being photographed. Your image may show up for a commercial purpose to sell my photography services before you enter. You know. By attending this wedding, you get.
Concerts, does that stand out?
Concerts tickets have those, yeah.
But most wedding photographers,
parks all the time.
Correct.
but most wedding photographers provide an album.
Next to the holy water.
Exactly.
So most photographers show an album that shows work that was shot the entire day.
Right.
So in that album, there's going to be images from the different groups that were taken
Not,
during the day. to help them book.
not a commercial purpose, arguably.
In other words, if you took that image of the bride and put it on a coffee cup and sold a coffee cup.
That's a problem.
it would be considered commercial.
That's the problem.
Your own website is not considered commercial.
It is, but how you use it on the website is what matters.
I'm not selling her picture to strangers.
Just to promote.
Just like displaying it as an example of your work.
With like a little speech bubble that says, "Oh, try our photography." Like
Yeah,
that would
here,
be
so-
one example of where you'd be misusing that image.
What about smoking? If we sell the pictures there for this trip?
Not a commercial purpose.
You're not like advertising with that image directly.
So like this picture was taken of me in my office to sell attorneyfee.com. And if I don't think the site's up, maybe it's a page. It doesn't matter. I'm just giving you an example of if it's still up. It might not be up anymore. But so Attorney Fee is a site that links people to attorneys, and they came and they wanted to showcase some of the attorneys that they can link people to. And so when you go to their site, which is not loading, it has my picture as like the LegalZoom like picture on top. That is selling attorney fee. But if it was just a picture of me on the site as a listing, different. I'm sorry it didn't open up. That's unfortunate. No. I mean, I knew about it. They came. No, the site's down now. Did I do everything?
Then had they not asked your permission, then.
Right. Then that would be a problem because maybe I don't want to be affiliated with attorney fee.
Now, what about if it's like a building?
I think there's one of those things where like if you know,
Question that somebody might ask. Can I ask a question? So I'm the photographer and I just uploaded 1,000 pictures from this wedding and it is for sale on this
Online gallery.
link. So is that gonna get me in trouble? It's like if somebody sue you and say, hey, why is my picture for sale? I know you took a picture of me at the
People can always sue you. Yes.
You'll never be out of it.
Yeah, right. Whether or not they'll be successful is a different question. So, I mean, again, those are the elements. Use the picture, commercial purpose, without your permission.
Yeah,
What's the commercial purpose?
The question
Depends.
is, are you acting consistently with people's expectations? People who attend weddings expect that people will have an opportunity to buy table shots or whatever pictures that they hear, and so the likelihood of anyone coming after you.
Oh, I'm sure there's crazy exes that,
Well, lawyers have to make a living too, just like the doctors.
Speak. So, by the way, I'm big on social media, so if you are as well, follow Saper Law on @saperlaw.com or @saperlaw. I actually do a lot of seminars at my office on a regular basis. If you look at our events page, you can kind of see where I'll be and where I'm speaking.